And today we want to talk to you about a recent case law development, case out of the Northern District of California, up in the Bay Area. And it has to do with service of process via social media. Seems very interesting. So I'm going to throw it out to you, Scott, to tell us what exactly happened. Are you able to serve someone via Twitter, Facebook, Instagram? Can you do that?
So there was a recent decision out of San Francisco, like as you were talking about, by Judge Beeler, and she found that an American plaintiff could sue a foreign defendant and serve the papers via Twitter only. There, the other means were, they were unable to serve via other means. They didn't know where the person was, and the foreign government wasn't accepting service, helping out.
Do you know who the parties are and what the claims were, just to give us a little flavor?
Yeah, so it was an American charity, and it was ISIS fundraisers were the defendants. So not
the defendants are ISIS fundraisers, okay. And the plaintiff is an American charity for, what, do you know what type of charity?
It was a Catholic charity.
A Catholic charity suing an ISIS fundraiser, and what was the claim?
The decision actually, it was for terrorism-related offenses.
I see.
And obviously not the most sympathetic defendants, and very much a sympathetic
worst people on earth.
Yes. And the judge allowed them to serve via Twitter only because it was the person they were targeting was very active on Twitter, and so it was a reliable method of serving the person. And in the past, judges have allowed service by social media, but there had to be some other method in those cases. Not that they specifically held that, but all the other cases, there was, for instance, service by Facebook and email, service by Twitter and mail. Because one problem with a lot of these foreign defendants is that it's very difficult under international law to serve the people, because most countries you cannot serve by mail, and you can't just go there, hire a process server and serve the person personally. You have to go through the government.
Well, we have had experience in a country like India where we've just been totally frustrated because the papers, Steve, I think you worked on this case and continue to, the papers go to a central authority and it's just a bureaucracy and nothing gets done. So, okay. And I understand you have, so getting back to the email point, I mean, you and we have experience actually with this judge serving a foreign defendant through electronic means. Can you remind me how we did that and the process?
So Judge Beeler allowed us in a case, it was a copyright infringement case involving Chinese national defendants. And for two of the defendants, all we had were email addresses. We didn't know where they lived. All we knew is that they were somewhere in China and that we knew their email address. And so Judge Beeler allowed us to serve the papers via email only. Now, one thing that's important for attorneys and people to realize is that you need to prove to the judge that this really is the person's email address. So in that case, we were able to prove it because we had communications with the defendants by email. And so because we had those communications, we were able to tell the judge, hey, we know it's their email address because we have emailed them ourselves. You can't just go randomly say, oh, I heard this is their email address. You need more proof than that.
Well, on that point then, let me throw this to Steve, and Steve, you may or may not know on the case, and Scott, if you know, chime in, but on that point, proving that it's someone's email address, with a Twitter account, in this case,
right,
there's a lot of fake Twitter accounts out there. I mean, we have internet impersonation cases all the time. So did the court set up a standard? Do you even have to prove that it's the defendant's Twitter account that is being accessed regularly?
You have to prove it, but it's not, the court didn't set out a specific standard. In this case, the defendant was a Kuwaiti national that had used that Twitter account specifically for, had a significant following through that account, had used that account for activities related to the case. So there was, in the court's eye, more than a sufficient means to show that the Twitter account was actually connected to the person that they cared about. So there, and like, it'd be similar to celebrities or other people with lots of followers and high profile, if, especially where the account is connected to the activity that you're suing on, you know that the person that you are interested in is connected to the account.
Yeah,
With
with
a high
regard-
degree of certainty, you have a lot of evidence there. I believe there might have even been some evidence from a State Department report that this individual had been using Twitter in connection with these activities, and there might have been extra evidence there.
Okay, so, I'll throw it open. Is this opening up a new path now, a new pathway to serve people? Because it is a real practical challenge. I mean, listen, guys, we've experienced it in a case in India where basically we could not get service done. It was against a large media company, by the way. Right, guys?
Well, we were able to serve the media company and the large defendants. The problem was serving the smaller player
smaller
individuals.
Whoever it was, it went into
Yeah.
bureaucracy and we couldn't get it done. So if you can sidestep that and serve someone via Facebook account or a Twitter, I mean, I think that would be a great tool. So is this helpful in doing that?
I definitely think so. I think it's also a very reliable method. It's much easier to tell that this is someone's Twitter account or Facebook account or LinkedIn account than it is other methods of service that courts have traditionally allowed. For instance, a common form of alternative service when other forms of service have failed in a lot of states that you can just give notice in 2 newspapers. And what's the chances that somebody's actually going to have looked at these 2 newspapers?
Yeah, service by publication, I think, is way, way, way less reliable than doing it by social media, that's for sure.
Yeah, absolutely, and it's an enshrined method that's been used for a long time, so that's why it's still there. But this is service by publication by another means. It's publication to some channel that's actually targeted to the person. It's important to note, though, this is not a domestic service issue. This isn't only for federal courts trying to serve international defendants or someone that's outside of the country. And I think one of the key reasons why this has been sort of a growth area in the law is that it's so new, there aren't actually international agreements and international laws prohibiting it. And that's one of the key things in the United States law that's allowing this to happen, is the law says, well, it can't be something the other country prohibits. And as Scott mentioned earlier, there are several countries out there that prohibit service of process by mail and would want you to go through their central authority instead.
Okay, now the last point is on the flip side, if we are representing someone who may likely be sued in America and they're a foreign company or individual and they want to avoid service and that's one of their key strategies, then the advice would be shut down your social media accounts. So for all of you Europeans, all of you Asians, all of you South Americans out there who may be about to be sued in America, I think that you may want to close down that Facebook account. That's all the time we have for this week on the Reins Feldman Separate Liability Update. We will see you next time.